Hello and welcome to the HOA Show, where we discuss the news, problems, trends, and critical issues relating to life in a homeowner association. Join us every episode, and together we'll explore how to survive and thrive in the dizzying world of HOAs.
Hello, and welcome to the HOA Show. In this episode, we'll be discussing successful rules enforcement during challenging times. I'm your host, Ryan Gazelle, and today we're joined by well-known CID attorneys Lisa Tajin and Jeff Beaumont, as well as Timothy Klein. Lisa and Jeff are the named partners of Beaumont Tajin Law Firm, and they specialize exclusively in law for common interest developments. They're both very active in many chapters of CAI as well as CACM, and both frequent speakers all over the state of California for these organizations. Jeff has been practicing HOA law for more than 20 years, and he serves on the faculty for CACM and CAI National, as well as the Legal Steering Committee for CACM, and a delegate for the California Legislative Action Committee for CAI. Fun fact, Jeff and I actually went to the same high school, although for the record, we were not there at the same time. He was there well before me. Lisa is the past president of multiple chapters of CAI and has been practicing law for quite some time as well, although her bio online does not say how long because you never ask a lady for her age. Am I right?
You are right, Ryan.
And finally, Tim Klein is the CEO of Klein Agency Insurance Brokers, which he founded in 1998. And he's been specializing in common interest developments since the mid-'80s. Welcome to the show, guys. Thanks for joining us today.
Thanks, Ryan.
Ryan?
We're very glad to have you both on here to discuss this, Lisa and Jeff. Obviously, many Americans are going through a really, really rough time right now. There's a lot of folks out of work, struggling to make ends meet, and most people are spending a lot more time at their homes, which are all factors that are going to make life more difficult for a board of directors. Before we get into your recommendations on how to successfully enforce the rules during these challenging times, I'd first like to ask you both, what are the most common issues or rule violations that you're seeing communities struggle to deal with right now?
Well, Ryan, Tim, thanks for having us. And right now, we're seeing a really influx in complaints in our clients' communities surrounding nuisance, noise, parking. We're seeing a lot of people working and staying at home because of the pandemic, obviously. And what that's resulting in is more density, which means more people living in close proximity with one another. And that's resulting in a lot of conflict in communities that centers on noise and nuisance complaints, as well as parking. There's just a lot more people at home now at the same time before it spread out a lot more. And unfortunately, what we're also seeing is people not just staying safe at home, but working at home. So what used to be normal hours of the day where noises and certain sounds and conduct was acceptable may not be acceptable now because there's more people at home trying to make a living and earn a livelihood.
So that dog barking while you're on your Zoom call is not helpful.
Exactly. So that's what we're seeing right now.
Absolutely. And, with that comes the issues of the amenities. Because people are home, they want to use amenities, whether it be the pool, the spa, the tennis court, the gym. But as we all know, there's been a lot of state and local orders that really prohibit the use of those facilities. And it's a very fluid thing. Every week there's different orders that are being issued that revise the requirements to keep those facilities open. So what's really challenging for a lot of our clients is the closing of these amenities, the reopening of these amenities, and under what circumstances they can do it. And so a lot of our clients are really turning to us to help them navigate through orders that are issued by Governor Newsom as well as local county orders. And again, like I said, those are very fluid and they change on a weekly basis. But what we're seeing is these orders are requiring really strict social distancing requirements if the common area facilities are going to be opened. So what the first wave was closing those amenities. And of course, people are getting upset and they're at home. They don't have any outlets. They want to use the pool, the gym. So the first wave was trying to help our clients disclose those amenities and really educate the residents as to why we're closing them and what the ramifications are going to be if they do try and use these amenities while they're closed. Now what we're seeing is there's been a relaxation of those social distancing requirements, and these orders are now allowing for amenities such as the pools and the gyms to open under certain conditions. So really trying to get our clients to understand what those social distancing requirements are, keeping a 6-foot distance from others that are not in your household, wearing masks, using hand sanitizers, posting signs in regards to the use of those facilities and the assumption of risk, as well as really monitoring the capacity, because these orders are requiring these components, these common area components, to only be used up to 50% capacity. So the biggest, I think, struggle for a lot of our communities are how do we monitor these social distancing requirements in our pools, in our gyms, in our saunas, in our tennis courts. So with that really comes the issue of how are we going to make sure that that is happening. So clients are really dealing with, do we hire an outside third-party vendor to actually be a pool monitor or a tennis court monitor? Are they going to use association staff and train them on how to enforce social distancing requirements? So there is a financial component to this that a lot of our clients are struggling with, because if it's not in their budget to pay for someone to monitor, will they be in violation of the local or state order, and does that expose them to liability? So what we're seeing is a handful of our clients are making the evaluation and saying, we really can't reopen because we can't meet these monitoring needs. And the monitoring needs are not specified in the orders. They just say it just has to be reasonably monitored. So a lot of our clients, to err on the side of being cautious, are keeping the amenities closed because they feel they can't meet the city or the state's orders. Other clients are choosing to build into their budget a line item that is going to pay for a outside monitoring service. So it's really a case by case for each of our clients.
So Lisa, let's say that a community, they make their decision on what they're going to do, and they decide not to open up. The pool is closed, or they put in those restrictions of you can use the pool according to these guidelines. How do they enforce those rules if those rules are then violated?
That's a great question, and you just hit the nail on the head, Ryan. You need to have a rule. So obviously, no one has anticipated this pandemic, so we don't have rules in place that tell you how to use the pool under restricted conditions. So all of our clients have had to adopt emergency rules, which Jeff will talk about on how to do that. You need those rules in place before you can even have any type of successful enforcement, because without a rule that correlates to the violation, the association has no teeth to enforce. But Jeff, why don't you tell us a little bit about face masks, because that's a big one.
Sure, and that relates to the amenities. And to go back to your question, Ryan, to Lisa's point, the rule is really the foundation for the building. And Lisa also mentioned a lot the word liability. I'd like to ask Tim a question about that as it pertains to boards being concerned about being sued for how they enforce. But real quick, to answer your question, Ryan, Civil Code Section 4360 is that civil code section that we've all become familiar with and really embraced, that requires boards to engage homeowners through the rulemaking process and requires a 28-day comment period. But there's an exception that says if the board determines that an immediate rule change is required to address an imminent threat to public health or safety, that's the key. And here we have an imminent threat to public health or safety. So the modification of use of the amenities requires an emergency rule to reorganize how those amenities are used and to ensure that the board has the authority to enforce those regulations if someone's non-compliant. That would be calling them to a hearing. Obviously, these are tough times. So, our position, which is shared by a lot of organizations like CAI and CACM, we're trying to educate our boards through information and to be compassionate, and hopefully that resonates. And boards and managers are educating the homeowners about the benefits of these rules and how we're all trying to just stay safe and healthy. But if push comes to shove, which ties into my next topic, face covering, boards sometimes are forced to go forward with compliance, and that really relates to the liability issue, which a lot of boards are afraid of pursuing compliance because they feel that if they're sued, there isn't going to be any insurance coverage because they feel that there's a virus exclusion in the liability policy and that they're going to be exposed to personal liability. And that's really been a hot topic too, as we've navigated through compliance and helping boards adopt rules and enforce. And I don't know if you, Tim, if you've come across that in your office, and if that's become a hot topic as well.
It has become a very hot topic, and the issue really surrounds the selective enforcement and consistent enforcement of the rules. And that's whether there's a pandemic or not. The rules have to be enforced consistently and fairly. And unfortunately, with turnover of board members and new management companies, sometimes the rules are enforced inconsistently. And those are the challenges, I think, and the reason that we see these type of claims show up under the directors and officers liability policy. Now, what's interesting about the pandemic is there's claims potentially before someone actually is found to be with the virus, and there's claims that occur after. And the claims before are potentially covered under the directors and officers liability policy. If there's actually bodily injury that takes place, then in that event, we have to go under the general liability policy, and there are obvious exclusions that could potentially apply under most general liability policies. But, the plaintiff's attorneys are very creative with regard to these type of complaints, and we really won't know until we submit to the carrier, and our advice is to always submit early if there is the potential for a claim, and let the general liability carrier adjuster sort things out and see whether or not they believe there's coverage.
And on a previous podcast, we had discussed opening pool amenities and other amenities during the pandemic. And Tim had mentioned that we'd recommend that all of the owners or board of directors notify their owners to make sure that they've got loss assessment coverage. Because in the event that the general liability policy denies coverage, they may be able to collect under their loss assessment policy. Isn't that right, Tim?
Yeah, I agree. Obviously, we have no way of knowing because there's such a variety of policies, and each carrier's form seems to be somewhat unique. We have, however, found that most loss assessment policies are many times broader than the underlying general liability policy. So I think that would be well advised for board members to tell owners in their communities to get as much loss assessment coverage as they can purchase, preferably about $50,000 for the loss assessment coverage per owner would be a good starting point.
And Jeff, getting back to these rules, I imagine that most law firms that specialize in HOAs right now have already put together some sort of a template or something. Are you calling them COVID rules? What's the deal?
Yeah, I think that what we're seeing is what we're practicing. That is, most firms are providing their clients' boards with a set of rules that specifically addresses the current pandemic. And we're going to be in situations in future years dealing with emergencies. We live in an earthquake country, but this is very specific because the virus is going to do what it's going to do. And it changes, like to Lisa's point, every day, every week. And so these rules that we're putting together and that a lot of other law firms are putting together address what needs to be addressed, but what really needs to be done is a step taken back and really to consider the needs of each particular community. Each community is different. For example, with respect to the face covering issue, that's a requirement that individuals wear face coverings when in public and common areas. So how does that relate to HOAs? And that's become a safety issue. It's become a political issue. So with that being in a set of well-crafted rules that specifically addresses the needs of a particular community, we're able to help boards really fulfill their fiduciary duties, and to Tim's point, consistently enforce. And that sometimes means making the difficult decisions. And it's different in a high-rise or in a mid-rise where you have confined areas, you have elevators, you have enclosed common area walkways. which is much different than a condo outside, in the, let's say, Santa Clarita, outside greater Los Angeles area, where there's expansive greenery and green belts and open space. Much different. So we're telling our clients and boards and managers that are managing high rises in communities that are very, very dense to be very consistent and assertive enforcing their face covering rules. And then those that are in different types of communities that are much more expansive and wide open, to narrowly tailor their rules to address only certain limited areas that make sense from a social distancing standpoint.
But what does that enforcement look like? Somebody's not wearing a mask. What happens?
We're talking about a compassionate approach, a soft approach, an approach that I think a lot of boards and managers aren't used to, which is picking up the phone and trying to educate them and seeing if they're aware of the violation, if it's someone in their family. If they are, then and they continue to violate, then the warning letter, which includes, a letter that is intended to be shown on the 5 o'clock news. We have to assume that everything we do is going to be the spotlight of a newscast or a segment. So we have to be compassionate and still educate in every communication we have with them. And then after the warning stage and that soft approach, if there's complete and blatant violations and the disregard for the rules, which is a disregard for the health and safety of our neighbors, then the board has to go through that process. Maybe Lisa, you can touch on what that hearing process looks like.
Yeah, absolutely. And just on the face covering, this is a big one where I have clients saying, how do we enforce this? Because look, none of us are used to wearing face covering. It has not yet become second nature to grab your face mask every time you leave your unit or your residence. So a lot of my clients are saying, we really don't want to call someone to a hearing just because they simply forgot their face mask. So there is this soft approach, as Jeff mentioned, where if you're going to have a rule requiring face coverings, have some disposable ones at the front desk or at the manager's on-site office. And if you see someone coming out of their unit, just give them a gentle reminder. And really, their reaction is going to dictate whether it was an honest mistake, they literally just forgot, and they run back to their unit and get their mask, or if it's a blatant disregard of the rules, in which case the hearing is going to be required. And hearings, and there's also another wrinkle when we're dealing with hearings. Because when you call to a hearing, if it gets to that point where it is that blatant disregard and you have to call them to a hearing, hearings by the civil code are required to be held in person with the board. Obviously, this has been impacted by the pandemic and the social distancing requirements. So many of our clients are resorting to Zoom or conference calls or some other platform that allows for video conferencing to hold those hearings. Is this a technical violation of the civil code? Yes, it's supposed to be in person. But our position is we'd much rather defend an association who exercises restraint and control and reasonableness in an effort to ensure the safety of its residents and its owners. And having that meeting by Zoom is obviously the safest way to go. So if an owner is going to make a claim or file a lawsuit because the association violated the civil code by not having that hearing in person, we feel that we'd have a very strong defense, just the mere safety of owners and wanting to comply with the governor's and local county orders is far more important. So we're having those meetings by Zoom, those hearings. They've been very successful. Jeff and I have had many of them over the last couple months, and they work out perfectly, and while ensuring the safety of everyone involved. So that's the process we need to go down. But it's also important that we can't emphasize enough this is not a normal rule enforcement. This is not just a normal noise violation. Everybody has to be on heightened alert, that we have to be compassionate. We've never faced such a situation before as far as a global pandemic. And so we're all learning as we go as far as what is the best way to proceed while balancing not only the rights of people who are now home, losing their jobs or had a pay cut, but also ensuring the safety of everyone in these close quarters.
I guess it gets back to what you were saying about don't end up on the 6 o'clock news, right?
Exactly.
I was just concerned that if the association has these various rules, how does that not inadvertently provide an assurance, maybe an ill-advised assurance, to a participant, whether it's an owner or a guest or invitee, that the board is warranting that the premises is safe? Do you recommend a waiver, or do you recommend some acknowledgement that the association has tried their best, but they do not warranty these premises are safe? I'd love to hear your advice on that.
Yeah, that's a great question, Tim. And the question of liability is a hot one right now. There's talk in the legislature, state, federal, about introducing legislation that will create levels of immunity for certain businesses, organizations for virus-related claims. The same is being discussed amongst groups in CAI National. At the end of the day, boards, I think I keep emphasizing this, each time there's communications with the homeowners, whether it's through trying to gain their compliance, whether it's adopting emergency rules, there has to be a reassurance that the board is not a guarantor of their safety. There's nothing that the board or anybody can do to guarantee the community is going to be virus-free. We all have to assume, in the documents Lisa and I put together for our boards and their management team, make it clear that there is a critical path that we all have to follow, which is a path that leads down the same road, and that same road assumes that everybody around us has the virus. And to that, we then have reasonable expectations that we need to socially distance, we need to wear face guards, we need to wash our hands, and follow the guidelines put out by the state and federal government. And I think that's key, because look, we're thinking about, Lisa and I as practitioners, helping communities, helping boards, helping management, is that we're going to be before a judge and a jury. And what do we want in our arsenal? To defend against liability claims. And we want those types of communications, which sets the expectations up realistically. And you mentioned the use of waivers, and I do think waivers help. I think it's another arrow in our quiver in the event that we're forced to defend our clients in a liability claim, but it has to be tied into the use of amenities that they're electing to use. If it's just frequenting common areas, ingress, egress, going to and from their home, from their car, I'm not quite sure that the requirement that they sign a waiver is the best practice. But if they choose to use the pool, if they choose to use the gym that's been moved outside right now, right now we're talking about gyms that are operating outdoors, because that's the only thing that's required or allowed. But before, they were being used inside. If they want to voluntarily put themselves in that position, they need to voluntarily sign a release of liability. I think that's a great tool in certain circumstances.
But it's also important to know that waivers are not a guarantee against a claim or a lawsuit. Obviously, anyone can still file a lawsuit having signed a waiver, but as Jeff says, it just gives us as attorneys another tool to use in the defense of our clients should an association be sued for COVID-related claims. So we definitely recommend a waiver, and we advise our clients it's not bulletproof, but it definitely helps to defend the association if needed. So on that note, another issue that we are seeing, just to touch upon it briefly, is construction inside of units. We have a lot of our clients calling and saying, there's a homeowner requesting construction, we're concerned, we don't want contractors in and out, potentially spreading the virus, and the more people that come into our community, the more likely it will be that this virus will spread. So can we say no? So the question really becomes, it's a little complicated, and it's between essential and non-essential. State and local orders have kind of identified essential services versus non-essential services. And essential services have been identified as professional services such as construction of residential and commercial real estate. Unfortunately, none of these orders are specific as to actual construction inside of a unit in a multi-family dwelling building. So we don't really know how that would be interpreted by a court if it was in front of a court. So what we're trying to help our clients do is to understand and to create policies of what's essential and what's not. Essential workforces have been identified by these orders as having to do with anything that is necessary for actually living in a unit, such as plumbing services, electrical services, even exterminators. So those types of contractors are definitely identified as essential. But the question becomes, what if someone is just doing some discretionary remodeling of their home, changing out floors or countertops? It's not essential for them to live in the unit, but they just want to upgrade their unit. Having a policy in place really, really helps homeowners understand what they can and can't do right now. Really, boards need to evaluate it on a case-by-case basis as the architectural applications come in. But we feel confident that, the board has discretion to determine what is discretionary or can be put off and what is essential to that resident living in that unit, which we should allow the construction to go forward. Obviously, whatever construction our clients allow, they can set reasonable requirements and restrictions, such as the contractor having to abide by all the social distancing requirements, the face mask, even limiting the number of workers in a unit at a specific time, even considering the ingress and egress to that unit. Is there a freight elevator that they can use as opposed to a passenger elevator that would help keep them segregated? Things of that nature. So really, it's up to the boards, I think, to consult legal counsel and create a policy of what type of construction will be allowed at this time. And then once those applications come in, evaluating them on a case-by-case basis to determine whether they would be deemed essential or non-essential. That's really the best we can do with construction at this time.
So the policy that you're making reference to would be different from the COVID rules. So you're saying that you would have guidelines about what is allowed within the COVID rules that they're adopting, and then further beyond that, a separate policy once the construction or the renovation has been approved?
Yeah, just having a policy in place that obviously is temporary. All these rules that we're talking about, and we're hoping they're going to be temporary, whether that's a month, 2 months, a year, but we're hoping they're going to be temporary in nature. So having a policy that says, in light of the COVID situation and the global pandemic and, in the interest of ensuring the safety of all residents, here is what the board is considering essential services as far as construction that will be allowed under certain circumstances as long as these social distancing requirements are followed to a T, as well as ensuring that the contractor has the proper insurance to cover any claims that might come up. But it would be something that would be kind of tied into the emergency COVID rules.
Yeah, and I think what also should be tied into the emergency COVID rules are rules addressing the delinquencies and failure to pay assessments. So that's another big issue, which I would recommend a separate segment on, which is how to successfully collect assessments during this time. It's a challenge. We're seeing a lot of different scenarios come up. And I think the number one issue, or at least message that resonates, is just compassion, but also responsibility. And the compassion is what it is. People are out of work. We've got more people on unemployment now than ever. And the responsibility part is the board's obligation to not just levy assessments, but collect them. So there's that balance here that we need to help our clients strike, and boards and management. And this could be addressed in the emergency COVID type rules that allows boards to, let's say, homeowners enter into payment plans that maybe puts aside or puts into forbearance a certain amount of months of assessments. They're not waived, they're owed, but they're not going to be charged late fees or interest. The owner agrees to start paying assessments after a certain time, and as far as the assessments that were not paid and cannot be paid, those will be paid down on a payment plan type basis. So there's all types of options available to boards that strike that balance between compassion and responsibility.
Absolutely. And just, going further on that theme of compassion, just remembering during this time, first responders, doctors, we've had a lot of clients those that have first responders that are living in the community that are asking for variances or accommodations and waivers of certain rules, such as RV parking. We've had a lot of residents who are first responders. They've been exposed to the virus. They don't want to expose their family. And they've asked if they can park their RVs on the street, even though that is normally not allowed, so that they can live there and self-quarantine there. And, we at first we had clients saying, absolutely not, no way, we don't want to allow this. And, Jeff and I, again, try and ensure that the 6 o'clock news is going to be our friend.
Mm-hmm.
You definitely want compassion, to show compassion to these first responders that are on the front end facing this virus, and to deny them a variance for parking during a temporary time frame so they can self-quarantine and keep their family safe would be the wrong decision.
That'll get you on the 6 o'clock news for sure.
So we're working with our clients to see that and to work with these first responders. These are all novel issues that are coming up.
That's a fantastic point, Lisa. I hadn't even considered that. You gave me chills.
And what's interesting, Ryan, is CAI National caught on to a Facebook group that was just really, really gaining traction. And it was a very, very, very interesting group that organized early on to network amongst RV owners to make posts of first responders that needed RVs to live in to protect their families. And they would travel and drop them off at these first responders' homes so they can live in. CAI caught on to that early because there started to be posted on these groups, on these forums, complaints about the HOAs going after them for violations. And so CAI formed an ad hoc committee. I was a member of it, and we put together a position statement. And talking through it, we agreed that not only is CAI going to take a compassionate position and support first responders, even if it means relaxing rules that prohibit RVs in communities, but it's going to be expanded not to just to first responders, but to family members, because there could be a family with someone that has tested positive that needs to self-quarantine but doesn't want to be away from their family. And so the next logical step is to take their RV, park it out front, so they can be at least in close proximity to their family while they go through this period of quarantine. So that was something that was really enlightening and I think has helped a lot.
Wow. Yeah, that's a wonderful idea.
Yeah.
So Lisa, I know you're going to touch on what my passion is the fine schedule, because we're talking about enforcement. How do we put some teeth into enforcement? And then I was going to end with maybe talking about how to approach your emergency rules and to reevaluate them at certain times.
Yeah, as far as the fine schedules, I mean, because we're dealing with life safety issues, it's really important to evaluate your fine schedule. Every association needs one, otherwise they can't impose fines. But of course, we never dreamed we'd be facing a pandemic and dealing with life safety issues where someone's violation is not only a nuisance, but could impact someone else's health or even cause death. So we need to reevaluate fine schedules and make sure that they are adequately addressing the pandemic-related violations and ensuring that they're high enough to serve as a deterrent for any life safety violations. So I have a lot of our clients who are increasing their fines and even having an addition to their fine schedule that addresses specifically COVID-related violations, which are going to be more severe as far as penalties go.
And this revised fine schedule, would that be part of the pandemic rules that are adopted?
Yes, absolutely. And Jeff will talk to you a little bit about how emergency rules are adopted, because it's not the same as regular rules. So it would be part of that. Absolutely. The fine schedule would actually reflect violations for COVID-related issues and would be definitely high enough to prevent people from, or at least think twice before they violate any of the COVID emergency rules that are in place.
Before Jeff jumps in on that, have you had any practical experience with these violation letters going out? Are they met with anger and resentment?
That's a great question. It's kind of all over the spectrum. For the most part, I think the violation letters have been few and far between. I think people understand the severity of the situation and are complying. But we definitely have had people who are so angry that they can't use the gym or they can't use the pool or have to do so under restrictions. So there have been a few. I would say most people comply, but there have been a few that don't, where the board has to kind of have some firm, aggressive, vigilant enforcement because again, it's not just a nuisance issue, it's a life safety issue. And, there's potentially no insurance. And Tim, you can speak to this as far as COVID related claims under a master association policy.
Yeah, the challenges are significant because it seems that many carriers over the last decade have added on various virus pandemic exclusions, which are very challenging.
I was going to ask you, Lisa, obviously in this day and age, everybody has a cell phone. I would imagine in a lot of cases that if a board member or a unit owner sees somebody that's not wearing a mask, they are going to whip out their cell phone and take a picture or a video to try to document that. And I imagine that would open up a whole nother kettle of fish. Are you recommending they not do that?
Oh, you mean and submit the violation to management or the board?
Yeah, if I'm a board member and I see Jeff walking around without a mask on, and the rule is in my community and my city that you have to have a mask on, and I take a picture of it and send it to the board of directors, does that create more problems than it solves?
Well, any type of self-policing like that, of course, creates issues, whether it's a COVID-related violation or not. Having someone walking around with a cell phone snapping photos always creates a feeling of a police state. But other than that, look, at the end of the day, if someone sends in a picture of someone not wearing a mask, does that warrant a warning letter to be sent to that unit saying, look, we know that you left your unit without a mask. Maybe it was inadvertent on your part, but, take this as a warning. And obviously, if they're repeat offenders, then the board has an obligation to go further with the enforcement, calling them to a hearing.
I think, Ryan, your question is a great one because that raises the issue of how the board enforces. And if a community was to encourage self-policing and self-monitoring, what may happen is when Ryan takes that picture of me, he may find himself in a headlock on the lawn wrestling with Jeff. And because I'm older and smarter, I may put him in a half Nelson, put him out of commission. but that's a big liability issue. So the board should not encourage self-policing. But what's interesting about your question is we haven't been involved that much with compliance issues. For the most part, communities are really policing, but through education and pressure. I've seen residents address fellow residents, even though it's not encouraged and certainly not part of the policy. They're taking upon themselves to ask their fellow residents to please wear a face covering, to please stand their distance. And it's worked, although there's been a couple cases, and mainly in high rises and communities that are very dense, where we've had to help boards enforce those stiff fines. And I think the way we've set up our COVID emergency rules and fines, it's really opened people's eyes that, whoa, if I am subject to discipline because this is a health safety issue, I'm going to be nailed or subject to a schedule of fines that's much, much stiffer than the fine that I could be faced with if I just don't pick up after my dog. Completely different scenario, completely different amounts, and hopefully that results in a motivation to comply. And I think that's what is key here, is that boards monitor this situation, the pandemic, on a week-by-week basis, determine if the emergency rules need to be modified. And if they do, there's a law that says under 4360 that if you adopt emergency rules, they're only good for 120 days. After that 120-day period, you have to adopt them following the 28-day comment period. But if you make changes to them, you may be able to re-adopt them as emergency rules. So it depends on how they're changed from 120 days to 120 days. But based on the trend we're seeing, there's so many changes that boards are having to modify them to adjust to the states and the counties and the cities' mandates, which is, again, it's making sure we're keeping our ears on the ground and our community and our sites and responding to our needs and not the general public's needs.
Well, like you said, you go and you adopt these rules, but as you said, they're changing. Things are changing. We're locked down here in California, and then, say a community adopted those rules and then we opened back up again. Do they then have to change the rules again? and then change them again once we close down again? How often do they have to monitor this?
Yes, that's the key. The answer is yes, yes, and yes. So every time there's a change that warrants a change to the rules need to reflect and mirror the guidelines in the state's orders. So that we need to keep a close eye on that. We need to make sure that we're updating our rules as we progress through this pandemic. Just like we monitor our rules each year when the legislature enacts new rules, we want to make sure that we update our rules to reflect those new laws. Same thing.
Can you adopt the rules in such a way that it's tied directly to the municipality position?
You can. That's a good question. You can. So that way you're just telling homeowners that as the guidelines change, these rules will incorporate those new changes. You certainly can. I'm not a fan of that because that requires the homeowners to go out and understand what those changes are. I like to publish them, have them in writing, and to get them out in front of people in clear terms that make sense to our residents and that make sense to our amenities and our particular community, as it may impact our homeowners, and not just make general references to guidelines that may or may not go into effect in the future. But that's definitely an option.
And are you recommending that boards post these new rules in the common area?
Post and absolutely distribute.
Great.
Yep.
Was there anything else
Great.
you guys wanted to cover in your outline?
No, other than we did go to the same high school, but I wasn't that far in front of you.
And I guess one last question. Have you guys seen or heard of any boards making some terrible errors or doing something that we've now realized or you've now realized should be avoided at all costs in regards to the pandemic?
I personally would have to say no. I think overall, generally speaking, our clients are reacting with caution. They are not doing anything quickly and swiftly without complete deliberation and consulting legal counsel. I think everybody understands the severity of the situation and that we are dealing with life-threatening issues, not just the normal violations. So at least the clients I've handled personally, I don't see any of them having taken any missteps because they are thinking it through. They're very concerned and they're acting very cautiously. Jeff, I don't know if you've had any different experience.
I agree 100%. Towards the beginning of this, I was seeing many boards wanting and feeling the need and feeling the obligation to enforce, particularly the RV issue. And some of the communities that we're seeing complaints about noise and people working at home. And I think since then, boards have really learned what their parameters are and what they can and can't do. And I think a lot of boards, because of the insurance and liability issues, have taken care by reaching out to people like the client agency, you and Ryan and Tim, and people like Lisa and I, and Reserve Study prepares, preparing for the financial side of this, and they've really been very responsible and really proceeding carefully. There's a silver lining to this mess. It's definitely that. I've seen a lot of responsible boards. That feels good.
Well, that's great. Yeah. You've restored my faith in humanity. I guess in summary, then, the takeaways here would be have compassion. And if you haven't already, make sure you adopt a new set of rules related specifically to the pandemic.
Absolutely.
Absolutely.
Contact your legal counsel ASAP if you haven't. And toward that end, how can our listeners get in touch with you guys?
Well, they should
all call Jeff on his cell phone on a Saturday night at 8 p.m.
I'll give you that number right now.
Yeah, they can go to our website at HOAattorneys.com or reach us through our toll-free number, 877-887-9998. Or they can email us, which our email is jbeaumont or ltastian@HOAattorneys.com.
Brilliant. Tim, anything else to add?
Great job, you guys. I really am fascinated and encouraged by your thoughtful, compassionate approach. I mean, it makes a lot of sense. I wish you all the best with it.
And it's great to hear that these boards and folks have been pretty level-headed about everything so far with enforcing these rules. That's great. So thank you, guys.
We really appreciate the opportunity.
Yeah.
Yeah, thanks, guys.
Yes.
It's always good to collaborate with you guys. Great.
Absolutely. As we end our episode, we'd like to remind our listeners that if you have any comments, questions, or suggestions for topics that you'd like to learn about, you can email us at feedback@hoashow.org. feedback@hoashow.org. Join us next time on The HOA Show.
To share or subscribe to the HOA Show, visit us at hoashow.org. There, you'll be able to listen to other episodes, find helpful resources relating to HOAs, provide feedback, submit questions, and check out other great stuff. The HOA Show podcast has been made possible by the contributions of Klein Agency Insurance Brokers, leaders in the community association industry. The views and opinions expressed by the podcast, its presenters and guests, do not constitute legal advice. For more information on how the topics in discussion apply to you, please consult with your own legal counsel.